Honorable Chief Justice, and may it please the Court, my name is Aiden Hickman, and along with my co-counsel, Nomi Sellers, we will be arguing respondent in the case of Free Speech Coalition v. Paxton. I will be addressing the first point of whether asking for age verification does not place a burden on adults. Whenever an adult would like access to explicit content, it is to be expected of that adult to require age verification, just like how you need an ID for a strip club, a bar, or other experiences that would require certain ages to access it. Denver v. FCC states that the authority's discretionary nature and ultimate objective of protecting young viewers from these offensive programs. This aligns with our goal under HB 1181 of making it harder for viewers to access pornography, specifically young viewers. And the age verification that HB 1181 puts into place does this job as minimally intrusive as possible. It is a dangerous thought that for a long time, minors had unrestricted access to explicit websites. The state of Texas has put up a wall that is necessary, that places zero burdens on adults. It's just like adding card information to a site such as Amazon. The state just put up another one of those, but for explicit content. This is something that should have been done since its creation.
Honorable Chief Justice, and may it please the Court, my name is Nomi Sellers, and along with my co-counsel, Aiden Hickman, I will be arguing the second point as to whether pornography as it relates to minors is or is not protected under the First Amendment. The First Amendment was created in 1791 by James Madison. Congress shall make no law abridging the freedom of speech or of the press. At this time, pornography was extremely limited and less dangerous. However, starting at around the 1950s, porn, as it relates to minors, became and is still a serious public health and obscenity issue. The NIH, American College of Pediatricians, and many more scientific groups find that pornography can be harmful to minors. In Ginsburg v. New York, the court has found that there is a government interest in the protection of minors from obscene content and the restriction of porn in general as it relates to children is constitutional and viewed under a rational basis. Opposing counsel has stated that Ashcroft should be used as precedent for viewing this bill, HB 1181, under a strict scrutiny. However, this case does not fall under strict scrutiny because the bill, unlike the bill in Ashcroft, makes companies verify the age. However, in Ashcroft, the individuals posting porn had individually the responsibility to verify the age of their viewers, something that is impossible for them to do. This is important because it creates a larger burden. An individual doesn't regulate company policy. A company can easily and with no burden verify the age of its consumers, while an independent creator cannot, partially because companies have staff dedicated to the running of their services, including the limited censorship of their speech, as already done even without Texas law. To quote Ashcroft about COPA, COPA imposes criminal penalties of a $500,000 fine and 6 months in prison for the knowing posting for commercial purposes of World Wide Web content that is harmful to minors. Note that this does not say company, but poster. The individual is responsible for the regulations of what should be company policy. Uh, if we cannot use Ashcroft because it does not apply here, why should we use Ginsburg instead? Well, under the U.S. v. Playboy Entertainment Group, uh, this court, the Supreme Court, has cited Ginsburg, meaning that it is still good law. To quote the U.S. v. Playboy Entertainment Group court, this court has also recognized that material the First Amendment guarantees the right to see may not be suitable for children, and consequently held that legislatures maintain a limited power to protect children by restricting access to, but not banning, adult material. Compare Ginsburg v. New York. To conclude, pornography as it relates to minors has been, in the Supreme Court precedent, seen as not protected under the First Amendment to the same degree as high-level speech and pornography as it relates to adults. It also holds, under Ginsburg and U.S. v. Playboy, that the U.S. government can regulate the speech of companies as it relates to minors seeing pornography. What, if any, is the value of low-level speech, such as pornography?
Low-level speech, such as pornography, is protected, but only for adults, not for minors.
Was the First Amendment created to protect this kind of speech? Does that matter here?
The First Amendment was not created to protect this kind of speech, and it does indeed matter in this case. It was created to protect people, such as newspaper articles or people speaking in the streets. It was not created to protect pornographic material.
Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
Your Honor, only the platforms are impacted, and very few, or very minorly in the case of adults, as platforms are required to have both a health warning before accessing their websites and have the age verification, which barely impacts adults.
Why can or can't the government simply ban access to pornography online?
Your Honor, Denver v. FCC states that pornography cannot be outright banned because adults still have the right to view this low-level speech, but minors do not have the same exact rights to view this low-level speech. So HB 1181 makes it harder for minors to access it and still upholds adults' rights.
In what ways is the Texas law a content-based imposition on speech? In what ways is it not?
This bill only restricts the viewing of pornographic material, and it only restricts content when it's pornographic in nature. It does not restrict other things such as YouTube videos. It is content-based only whenever it is pornographic in nature.
Is including social media and search engines under the age verification requirement a reason to find this law unconstitutional?
No, Your Honor. Since sites such as Google and social medias alike are not pornographic in nature, this bill does not restrict them. Therefore, it is not a reason to strike this bill down.
The law requires age verification when more than one-third of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
The law would be more burdensome, but only for platforms. As in its current state, it is not as burdensome as this fictitious idea.
Ashcroft v. ACLU applied strict scrutiny to a law that burdened adults' access to pornography, to online speech, not the rational basis basis test. Why should the court not apply the same standard here?
Your Honor, Ashcroft does not apply to this case, as Ashcroft deals with adults' restriction of pornography, while Texas HB 1181 deals with minors, not adults. So therefore, strict scrutiny should not apply here. As Denver v. FCC states, pornography can be restricted, but not outright banned when minors are of the issue. Ashcroft v. ACLU identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
No, Your Honor. There is more porn since 2004, and while it is hard to measure, the NIH and other sources say that there is significantly more porn since 2004 when Ashcroft was decided. This impacts the practicality of a filter-based system, which would be, in all intents and purposes, impossible to fulfill the government's interest in protecting minors.
If this court were to find that the Texas law burdens First Amendment rights of adults, does this mean that the petitioners would win?
In this fictional scenario that you have crafted, Your Honor, yes, the petitioners would win.
Adults concerned for their privacy may not access websites requiring age verification. Is that a sufficient reason for striking this law down?
No, Your Honor. As we have previously argued, adults can make their own decisions about what data that they want to be kept, and in HB 1181, companies are not allowed to store the data. Adults can choose whether or not to spend their time on specific sites, and sites already collect their data regardless of pornographic material.
If this court finds that the law requires examination under strict scrutiny, does this mean that the petitioners win?
Even if case is viewed under strict scrutiny, the respondent still wins this case. The bill passes all elements of strict scrutiny. When minors are allowed to view pornography, there is obscenity and ethical issues. And this bill restricts only porn and all porn, so it is narrowly tailored to the governmental interest that is substantial and legitimate in protecting children from obscene content, as established in Ginsburg v. New York.
Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in traditional brick-and-mortar stores?
Your Honor, there are actually less privacy concerns, as no one can see the purchase or viewing of data online, whereas in a brick-and-mortar, they can see and they can also keep your data. Whereas in HB 1181, there is a provision saying that you cannot keep the data shown. So there's less privacy concerns with this bill than there is simply going to a shop that sells pornographic material.
In the years since Ginsburg v. New York, they have increased technology capacities. And have they increased or decreased in the privacy concerns associated with the age verification process?
Your Honor, privacy concerns associated with the age verification requirements has decreased for the same reasons aforementioned in the previous question. No one sees that you purchased this because there's no data that is allowed to be kept. Brick and mortar shops, however, have more privacy concerns.
Online access to harmful materials presents unique obstacles to parents trying to protect their children. If this law is to be found unconstitutional, what else can Texas do to protect minors accessing online material?
If this law is ruled unconstitutional, nothing substantial that can fulfill our governmental legitimate interest in the safety of minors can be done. This would be a grave mistake and would harm the government's ability to protect minors, as there is numerous amounts of data that shows that this is an issue that minors deal with, and it is harmful to minors. There's a significant amount of precedent that we have a government interest in doing this in Ginsburg v. New York, and it is very important for these reasons that the court rules in favor of respondent.